Before we begin, a quick and important disclaimer. The information provided in this video is for educational and entertainment purposes only and does not constitute professional legal advice. Family law is complex, varies significantly by state, and is subject to change. This content should not be used as a substitute for the advice of a qualified legal professional in your jurisdiction. We strongly urge all viewers to conduct their own due diligence and consult with a licensed attorney regarding their specific circumstances. For decades, there has been a pervasive, haunting narrative in the American consciousness. The idea that once a father enters a family court, he has already lost. You have heard the stories in hushed tones at bars, in the comment sections of support groups, and perhaps from your own father or grandfather. The common wisdom suggests that the system is an immovable monolith, a machine designed to default to maternal custody 100% of the time, leaving fathers as little more than a weekend visitor and a monthly paycheck. But what if the data tells a story that is far more nuanced, far more systemic, and arguably more hopeful than the anecdotal evidence suggests? Today, we are looking at a century of data that reveals a staggering shift. In the 1970s, a father's chance of winning sole custody was statistically negligible. By the 2020s, the rise of joint physical custody has rewritten the playbook of the American household. However, despite these gains, a massive gap remains. Why do fathers still represent only about 13 to 20% of primary custodial parents? Is it a biological bias in the judiciary? Or is it a hidden byproduct of the way we negotiate settlements outside the courtroom? We are opening the black box of U.S. family law statistics to show you exactly where the system stands in 2026. This video is the deep dive masterclass that the standard 5-minute news clip refuses to give you. We are moving past the emotional rhetoric to look at the cold, hard numbers that define fatherhood in the United States. Whether you are currently navigating a separation, supporting a friend through the process, or simply interested in the sociological evolution of the American family, this series will equip you with a historical and statistical framework. We are solving the problem of the unknown. By the end of this deep dive, you will understand the historical trends that led to the current best interests of the child standard, the impact of no-fault divorce on custody percentages, and how the shift from gender years doctrine to gender neutrality changed the landscape for every man in this country. We aren't just looking at the what, we are looking at the why and the how, providing you with a roadmap of the historical outcomes that have shaped the modern court experience. To understand where we are, we have to look at the 19th century, where the data would actually shock you. Contrary to popular belief, in the early 1800s, fathers were the default custodial parents because children were viewed as economic assets and a father's property. However, as the Industrial Revolution shifted the father's role to the breadwinner outside the home, the legal pendulum swung violently in the opposite direction. This birthed the tender years doctrine. This was a judicial presumption that during a child's tender years, generally regarded as under the age of 7, the mother was uniquely and biologically suited to provide care. This wasn't just a suggestion, it was a statistical wall. From the late 1800s through the mid-20th century, if a father wanted custody, he essentially had to prove that the mother was unfit, in a way that was often scandalous and nearly impossible to document. As we moved into the 1960s and 70s, the no-fault divorce revolution hit. Before this, you had to prove fault: adultery, cruelty, or abandonment. When the laws changed, the number of divorces skyrocketed, and the courts were flooded with custody battles they were not equipped to handle. This period marked the lowest statistical point for fathers in terms of custodial involvement. The tender years doctrine began to fade, replaced by the best interests of the child standard. On paper, this was gender neutral. In practice, the data from the 1980s shows that the status quo of the primary caregiver usually won the day. Since men were still statistically the primary earners, they were rarely the primary caregivers, leading to a self-perpetuating cycle where the father worked to support the family and was then penalized in court for having been the one who worked. Let's look at a specific case study from the mid-1990s. Census Bureau data from this era showed that roughly 84% of custodial parents were mothers. At the time, sociologists argued this was a reflection of societal roles. However, legal analysts began to notice a trend in the 10 to 15% of cases that actually went to a full trial. When fathers actually fought for custody in a courtroom, their success rate was significantly higher than the aggregate data suggested. This revealed a critical distinction: the difference between court-ordered outcomes and settled outcomes. A massive percentage of the losses dads experienced were actually the result of voluntary settlements made under the shadow of the law. Dads were being told by their own counsel that they couldn't win, so they didn't try, which then padded the statistics that said dads don't win. In the early 2000s, we began to see the shared parenting movement gain statistical momentum. States like Arizona and later Kentucky became laboratories for new legislation. Kentucky, for example, passed a law in 2018 that created a rebuttable presumption that joint physical custody and equal parenting time are in the best interest of the child. The impact was immediate and measurable. When you look at the historical trends in states with these presumptions versus states without them, the gap in father involvement isn't just a few percentage points, it is a chasm. In states without these laws, the standard schedule of every other weekend, amounting to about 15 to 20% of the year, remained the statistical norm. We must also address the financial data points. There is a strong correlation in the historical record between child support structures and custody outcomes. For decades, many states utilized a percentage of income model, which did not necessarily account for the time a father spent with a child. This created a perverse incentive system where higher custodial time for one parent resulted in higher transfers of wealth, potentially turning custody into a zero-sum financial game. As more states have moved to the income shares model, which factors in the actual number of overnights, we have seen a corresponding shift in how custody is negotiated. As we sit here in 2026, the landscape is defined by the 50-50 push. Modern data suggests that the traditional family court outcome is becoming an endangered species in several jurisdictions, yet it remains the dominant reality in others. The disparity isn't just between mothers and fathers, but between different zip codes. This deep dive is going to break down the specific variables that influence these outcomes. The role of the guardian ad litem, the impact of temporary orders that often become permanent, and the statistical reality of how a father's involvement in the first 90 days after a split dictates the next 18 years of his life. We are going to examine the primary caregiver myth and look at how modern dads are using data to prove their involvement in an era where domestic roles are more fluid than ever before. This isn't about blaming a system. It's about understanding the mechanics of a historical machine so you can see the terrain for what it actually is. To truly grasp the gravity of the current landscape in 2026, we have to dismantle the most significant legal hurdle fathers have faced in the last century: the transition from the tender years doctrine to the best interests of the child standard. Imagine a father in the 1950s named Robert. Robert is a veteran, a steady provider, and a present parent. When his marriage dissolves, the court doesn't look at his bank account or his character first. Instead, the court looks at the age of his children. Because they are 5 and 3, the law operates under a biological assumption that the mother is the only person capable of nurturing them. Robert is essentially a legal stranger to his own children from the moment the gavel hits the wood. This wasn't just a trend. It was the law of the land. The tender years doctrine was rooted in the idea that maternal care was a biological imperative that no man could replicate. By the 1970s, as the feminist movement and the push for gender equality gained steam, the legal system realized that gender-based presumptions were unconstitutional. Enter the best interests of the child standard. On the surface, this was a massive victory for fathers. It stripped away the mandatory maternal preference and told judges to look at a list of factors to determine which parent would provide the most stable environment. However, the historical trends show that while the name of the doctrine changed, the outcomes remained remarkably static for another 20 years. Why? Because the courts replaced the maternal preference with a new invisible metric: the primary caregiver rule. The primary caregiver rule is the statistical ghost that haunts modern custody battles. Even in 2026, many judges rely on the history of who performed the day-to-day tasks during the marriage. If a father worked 60 hours a week to provide a high standard of living, the court often viewed that as a disqualifier for primary custody. The data shows that the parent who took the child to the pediatrician, signed the permission slips, and handled the bedtime routine was statistically awarded primary physical custody in over 80% of contested cases during the 1990s and early 2000s. For dads, this created a catch-22. To be a good father, you had to provide. But by providing, you were often absent from the very micro-moments the court used to define a parent-child bond. Consider the case study of a father in 2012. Let's call him Michael. Michael lived in a state that claimed to be gender-neutral. During his divorce, he requested 50-50 custody. The court looked at the previous 3 years and saw that his wife was a stay-at-home mother while Michael was a project manager. Even though Michael was a loving father, the court's historical trend was to maintain the status quo. The judicial logic was that the child's life should be disrupted as little as possible. Therefore, the status quo of the mother being the primary caregiver was extended into the post-divorce life. Michael was granted the standard visitation schedule, every other weekend and one weeknight dinner. Statistically, this left him with approximately 18 to 22% of the parenting time. This brings us to a critical data point that most people overlook: the default to settlement. National statistics from the early 2020s indicate that nearly 90% of custody arrangements are reached without a judge ever making a final ruling. This is where the historical fear of the system does the most damage. Lawyers, looking at past case studies and the local judge's reputation, often advise fathers to settle for less than 50% time. They argue that if they go to trial, they might lose even the weekends. This creates a feedback loop. Because fathers settle for 20% time out of fear, the statistics show that fathers only have 20% time, which then reinforces the lawyer's advice to the next father that 20% is the standard outcome. It is a self-fulfilling prophecy of paternal absence. However, the data began to shift significantly between 2015 and 2025. Sociological research started to pour into the courtrooms, proving that children with active, high-frequency contact with both parents showed better outcomes in every measurable category: academic performance, emotional regulation, and even long-term economic stability. The American Psychological Association and various advocacy groups began presenting data that challenged the primary caregiver myth. They argued that a father's role is not secondary or elective, it is foundational. This led to the rise of the rebuttable presumption. Imagine a different scenario for a father in 2026 named David. David lives in one of the 20-plus states that have now adopted a presumption of 50-50 joint physical custody. In David's case, the court starts with the assumption that both parents are equally capable and should have equal time. The burden of proof has shifted. Now, instead of David having to prove why he deserves half the time, the opposing party must prove why he should not have it. This is a seismic shift in the historical record. In states like Kentucky, after passing such laws, the percentage of joint custody filings surged, and the number of high-conflict trials actually decreased. When both parties know the starting point is 50-50, the incentive to fight for total dominance vanishes, saving families thousands in legal fees and years of emotional trauma. Yet, even with these legislative wins, we have to look at the socioeconomic custody gap. Statistics show a direct correlation between a father's income and his custodial time. Fathers in the upper middle class are statistically more likely to secure 50-50 arrangements than fathers in lower income brackets. This isn't necessarily because of judicial bias toward wealth, but because of the resources required to maintain two full households capable of supporting children half the time. If a father cannot afford a two-bedroom apartment or a home in a safe school district, the court often defaults to the mother if her living situation is more established. This creates a statistical reality where custody is often tied to the ability to afford a legal and domestic infrastructure. Then there is the issue of the temporary order. In the world of family law, nothing is as permanent as a temporary order. When a couple separates, a judge often issues a standing order to manage the situation until the final trial, which could be 18 months away. Data suggests that in roughly 75% of cases, the final custody arrangement mirrors the temporary order. If a father moves out of the house and sees his kids only on weekends during the separation period, he has statistically established a new status quo. The court, looking for stability, is hesitant to change that routine a year later. This is the strategic trap that many men fall into without realizing the long-term statistical consequences. As we look deeper into the history of these outcomes, we see that the narrative of the deadbeat dad was often a statistical anomaly that was amplified to justify systemic exclusion. In reality, the data of the mid-2020s shows that when fathers are given clear legal pathways and equitable time, their rate of child support compliance and emotional engagement skyrockets. We are witnessing the death of the visitor father and the birth of the co-parent. But there is a dark side to this transition. As fathers have gained more ground in custody, a new type of litigation has emerged: the weaponization of domestic allegations. When the legal presumption moved toward 50-50, the number of high-conflict cases involving restraining orders and emergency motions saw a localized spike in certain jurisdictions. This leads us to a pivotal question that every father must face in the modern system. If the law is moving toward equality, why are so many men still being sidelined by the administrative machinery of the court? We need to talk about the hidden influencers, the custody evaluators, the psychological testers, and the state-funded programs that often hold more power than the judge themselves. These individuals operate in a gray area of the law where statistics are often replaced by subjective observations. In the next part of this deep dive, we are going to look at the invisible gatekeepers of the custody process. We will examine the data on how custody evaluators actually make their decisions and the specific behaviors that lead to a father being labeled as high conflict. We will also uncover the truth about how states are financially incentivized by the federal government through Title 4D to maintain certain child support structures, and how that money might be the secret reason why 50-50 custody hasn't become the federal standard yet. You need to see the money trail to understand the legal trail. To understand the inertia behind custody reform, we have to follow the federal funding that flows into state coffers. This brings us to a specific, often overlooked piece of legislation, Title 4D of the Social Security Act. In the 1970s, the federal government was concerned about the rising number of single mothers on welfare. To recoup those costs, the government established a program to incentivize states to collect child support from non-custodial parents. While the original intent was to offset the cost of public assistance, the program evolved into a massive administrative machine. For every dollar a state spends on child support enforcement, the federal government provides a significant reimbursement. Additionally, states receive performance-based bonuses based on the total amount of child support collected. Imagine a state administrator in the early 2000s named Sarah. Sarah's department budget is directly tied to the efficiency and volume of child support collections. From a purely fiscal perspective, the state is incentivized to maintain a system where there is a clear distinction between a primary custodial parent and a non-custodial parent. If every family had 50-50 custody with no money changing hands, the federal funding for enforcement and the bonuses for high collection totals would theoretically diminish. This creates an institutional bias where the administrative arm of the state may favor traditional custodial arrangements because they are more profitable for the state budget. The historical trends show that as long as federal incentives are tied to collection amounts rather than shared parenting time, there will be a systemic drag on 50-50 custody initiatives. This fiscal reality often trickles down into the recommendations made by the invisible gatekeepers, custody evaluators and guardians ad litem. Let's look at a case study from 2018 involving a father named Marcus. Marcus and his ex-wife were relatively amicable, but they couldn't agree on a schedule. The court appointed a custody evaluator, a private psychologist paid for by the parents, to make a recommendation. Historically, these evaluators have been trained in the psychological models of the 1990s, which prioritized a primary psychological parent. Even though Marcus was a fit father, the evaluator used subjective terminology, noting that Marcus was a secondary attachment figure compared to the mother. The data on custody evaluations is startling. In a significant number of cases, the judge adopts the evaluator's recommendation nearly 90% of the time. This means the real trial isn't happening in the courtroom in front of a judge. It is happening in a series of private interviews and home visits with an evaluator who may have personal or professional biases toward maternal custody. For fathers like Marcus, the evaluation process is a statistical minefield. If he is too aggressive in pursuing time, he is labeled high conflict. If he is too passive, he is labeled disinterested. The historical record shows that fathers who do not understand the specific psychological criteria these evaluators use are at a massive disadvantage. Step by step, the evaluation process often includes the administration of personality tests like the MMPI-2. These tests were designed to detect clinical psychopathology, but in family court, they are often used to draw conclusions about parenting capacity. A father who is naturally stressed or defensive during a high-stakes divorce might score high on the paranoia or defensiveness scales. To a trained clinician, this is a normal reaction to a crisis. But in a custody report, it can be framed as a character flaw that limits his ability to co-parent. By 2026, we are seeing more fathers challenge the validity of using these tests in family law, but the historical weight of these evaluations remains a primary reason why the 50-50 split hasn't reached statistical parity. Now let's talk about the impact of the status quo during the litigation period. Imagine if a separation begins today in April 2026. The father moves into an apartment while the mother stays in the family home with the children. This is a common move to de-escalate conflict, but from a statistical standpoint, it is often a catastrophic error. In many jurisdictions, it takes 6 to 12 months to get to a final hearing. During that time, the court usually issues a status quo order. If the father has been seeing the kids 4 days a month during that year, the court views that as the new normal. The historical trends show that judges are extremely risk-averse. They do not like to disrupt a schedule that they believe is working, even if that schedule was born out of a temporary emergency. We also have to look at the statistical rise of the high conflict label. Since 2010, there has been a documented increase in the use of domestic violence allegations as a strategic tool in custody disputes. This is a highly sensitive area, but the data indicates a correlation between the filing of a request for 50-50 custody and the filing of an ex parte restraining order. In many states, a restraining order, even one that is eventually dismissed for lack of evidence, immediately halts all parenting time for the father. This creates a gap in contact that can last for months. Historically, once that gap is created, the father's chances of securing equal custody drop by nearly 40%. This isn't just about the law. It's about the psychological impact of being absent during a child's developmental milestones. However, the year 2026 has brought a new wave of data regarding domestic relations referees and mediators. In an effort to clear backlogged dockets, many counties now force parents into mandatory mediation. The statistical outcomes of mediation are fascinating. When parents are left to negotiate without a judge, fathers actually tend to fare better than they do in a formal trial, provided they are well informed. Mediation allows for creative scheduling that a rigid legal system might not consider. For example, the 2-2-5-5 schedule or the week-on week-off rotation. Historically, these schedules were seen as too disruptive, but modern longitudinal studies have proven they provide the most stability for children of school age. To truly understand why the needle is moving so slowly, we must address the cultural perception of fatherhood that still permeates the judiciary. Despite the fact that men today are doing 3 times as much childcare and twice as much housework as their grandfathers did in 1965, the legal system's institutional memory is slow to update. Judges, many of whom have been on the bench for 20 or 30 years, grew up in an era where the father was the breadwinner and the mother was the caregiver. Their personal biases, often unconscious, color their interpretation of the best interest standard. Imagine a scenario in 2026 where a judge is presiding over a case. Both parents work full-time. Both have clean records. The father wants equal time, but the mother argues that the children are too young to be away from her for more than 2 nights. The judge, drawing on outdated theories of maternal bonding, might rule in her favor, not because the father is unfit, but because the judge's internal historical trend suggests that children need their mother more. This is the subjective wall that no amount of objective legislation can completely tear down. But there is a shift happening that is fueled by economic necessity. In 2026, the dual-income household is not just a preference. It is a requirement for most American families. As more mothers enter the workforce and more fathers take on caregiving roles, the statistical definition of the primary caregiver is becoming blurred. This blurring of roles is the greatest ally for the modern father in court. When both parents are equally contributing to the domestic sphere, the court's traditional reasons for favoring one parent over the other begin to dissolve. However, there is one final piece of the puzzle that almost no one discusses. It is the role of the state bar and the legal industry itself. Family law is a multi-billion-dollar industry in the United States. High-conflict custody battles are the primary revenue driver for many law firms. If every custody case was settled with a 50-50 default, the billable hours for family law attorneys would plummet. We have to ask, to what extent is the legal profession itself acting as a barrier to custody reform? In the next part, we are going to dive into the data on the financial cost of custody. We will break down exactly how much it costs the average father to fight for 50-50 custody across different states, the success rate of various legal strategies, and the shocking correlation between the amount of money spent on an attorney and the actual number of overnights awarded. We are also going to look at the rise of pro-se litigants, dads who are representing themselves, and whether they are statistically more or less successful than those with high-priced counsel. The numbers might surprise you. The financial reality of the American family court system is perhaps the most sobering aspect of this deep dive. When we look at the data from 2024 and 2025 leading into this year, we see a massive disparity between the cost of entry and the statistical likelihood of a specific result. To understand this, imagine a father named Christopher in 2026. Christopher is an average middle-class professional in a suburb of Chicago. He is not wealthy, but he is stable. When he receives his first retainer agreement from a high-end family law firm, the number is $15,000. That is not the total cost. That is just the price of admission to start the process. Historical trends in the United States suggest that a contested custody battle can range anywhere from $20,000 to over $100,000 per parent. This is where the socioeconomic custody gap becomes a concrete wall. Data indicates that fathers who have the liquidity to pay these high retainers are statistically 35% more likely to secure 50-50 custody arrangements than those who do not. This isn't necessarily because the high-priced attorneys are better at arguing the law. It is because they have the resources to engage in what we call discovery wars. These attorneys can file a high volume of motions, depose witnesses, and hire expert witnesses like forensic accountants and child psychologists to build a case. For the father who cannot afford this, the system often defaults to the most streamlined path, which is frequently a standard visitation schedule that favors the mother. Let's look at the specific case study of a father in Texas named Brandon. Brandon worked in the trades and had roughly $10,000 in savings. He wanted 50-50 custody of his two daughters. His ex-wife's family had significant resources and hired a top-tier litigation firm. Within 6 months, Brandon's $10,000 was gone, spent mostly on responding to motions and attending mediation sessions that went nowhere. By the time they reached a final hearing, Brandon was self-representing because he could no longer afford his counsel. This brings us to the rise of the pro se litigant. In 2026, it is estimated that in nearly 70% of family law cases in some jurisdictions, at least one party is representing themselves. Historically, being a pro se father was a statistical death sentence for your custody time. Judges, often frustrated by the lack of procedural knowledge, would default to the arguments of the represented party. However, the data is beginning to shift. With the advent of AI-assisted legal research and state-mandated simplified forms, pro se fathers are becoming more effective. But there is a hidden cost. Case studies show that pro se fathers often experience higher levels of emotional burnout and are more likely to make procedural errors that allow the other side to claim they are high conflict. This brings us to the correlation between attorney fees and overnights. A fascinating study of over 2,000 cases found that spending more money on an attorney does not linearly increase the amount of parenting time awarded. In fact, there is a point of diminishing returns. Once a father has reached a baseline level of competent representation, doubling the spend on a prestigious firm often results in only a marginal increase in time, or in many cases no increase at all. The real driver of custody outcomes, statistically speaking, is not the attorney's hourly rate, but the father's ability to document his historical involvement. Imagine if Christopher, our father from Chicago, kept a meticulous digital log of every doctor's appointment, every parent-teacher conference, and every evening spent helping with homework for 3 years prior to the divorce. This data is worth more than a $50,000 legal team. In 2026, the courts are increasingly moving toward a data-driven approach. Judges are less interested in emotional pleas and more interested in hard evidence of the status quo. Fathers who can provide a spreadsheet of their participation in a child's life are statistically more likely to overcome the primary caregiver presumption, regardless of what they spent on their lawyer. We must also analyze the impact of the hourly billing model on the length of custody disputes. Statistics show that cases where attorneys are paid hourly last, on average, 8 months longer than cases handled by flat-fee or low-cost legal clinics. This extended duration isn't just a financial drain. It is a tactical disadvantage for fathers. As we discussed in the previous part, the longer a case drags on, the more the temporary order, which usually gives the father less time, becomes the permanent status quo. The financial incentive for a law firm to keep a case active can inadvertently work against a father's goal of achieving 50-50 custody quickly. Now let's talk about the cost of expert witnesses. In a deep dive custody evaluation, a private psychologist can cost between $5,000 and $20,000. For a father, this is a high-stakes gamble. Historical trends show that if the expert's report is favorable, the father has a nearly 85% chance of the judge adopting that recommendation. If it is unfavorable, his chances drop to near zero. This is essentially privatized justice. If you can afford the expert, you can potentially influence the outcome. If you cannot, you are left at the mercy of the court's limited resources and potentially biased observations. In 2026, we are also seeing a rise in what is called unbundled legal services. This is where a father hires an attorney only for specific tasks, like drafting a motion or representing him in a single hearing, while he handles the rest of the case himself. Data suggests this is a growing trend among middle-class fathers who are trying to balance the need for legal expertise with the reality of their bank accounts. While the historical success rate of this model is still being studied, Early indicators suggest that it provides a middle ground that allows fathers to stay in the fight longer without going into life-altering debt. Beyond the legal fees, there is the financial cost of parallel households. To win 50-50 custody, a father must prove he has the infrastructure to support the children. This means a bedroom for each child, a home in a safe neighborhood, and proximity to the school. For many fathers, the cost of setting up this household while simultaneously paying child support and legal fees is the breaking point. Statistically, fathers who cannot establish a suitable second home within the first 6 months of separation are 60% more likely to be relegated to a visitor role. This creates a cycle where the father cannot get the time because he doesn't have the house, and he cannot afford the house because he is paying child support based on having no time. This leads us to a crucial realization. The history of custody outcomes is not just a history of legal doctrine. It is a history of financial endurance. The dads who stay in the lives of their children at a 50% rate are often the ones who manage to survive the financial gauntlet of the first 2 years. But what happens when the money runs out? What happens when the legal battle ends, but the conflict continues in the form of co-parenting? In the next part, we are going to look at the transition from litigation to co-parenting. We will examine the data on how 50-50 arrangements actually hold up over 5, 10, and 15 years. We will look at the statistics on parental alienation, how often it is alleged versus how often it is proven, and the impact of new technology, like co-parenting apps, on reducing conflict and protecting a father's time. We are also going to explore a controversial topic, the relocation case. What happens to the stats when one parent wants to move across the country? You won't want to miss the data on how courts handle the distance factor in 2026. As we move from the financial gauntlet of the courtroom into the long-term reality of co-parenting, a new statistical monster appears on the horizon, the relocation case. Imagine a father named Marcus in 2026. After 3 years of hard-fought 50-50 custody, his ex-wife receives a job offer 3 states away and files a motion to relocate with the children. Historically, this is one of the most volatile areas of family law because it is inherently zero-sum. You cannot have 50-50 custody if the parents live 800 miles apart. The historical trends for relocation have undergone a massive shift. In the 1990s, many states had a presumption in favor of relocation, meaning if the custodial parent had a good faith reason to move, the court generally allowed it. However, as the data on the importance of father involvement has solidified, the legal pendulum has swung back toward the center. By 2026, most U.S. jurisdictions now require the moving parent to prove that the move is in the best interest of the child, not just the best interest of the parent. Statistically, if a father has been exercising a consistent 50-50ths or 40-60ths schedule, the success rate for a mother's relocation petition drops significantly. Judges are increasingly unwilling to destroy a functioning shared parenting arrangement for a higher salary or a new relationship. To navigate this, courts in 2026 are increasingly relying on the distance factor formula. Let's look at the data. When a move exceeds 100 miles, the traditional midweek visit becomes statistically impossible. In these cases, the court often shifts to a long-distance parenting plan. This typically results in the non-moving parent, often the father, receiving the bulk of the summer break, every spring break, and alternating holidays. While the total number of days might stay close to 35 or 40% of the year, the micro-involvement, school plays, Tuesday night dinners, coaching soccer vanishes. The historical record shows that these long-distance arrangements are the most fragile, with a 50% higher rate of parental drift, where the distant parent slowly loses their emotional bond with the child over a decade. This brings us to the rise of co-parenting technology. In 2026, the digital footprint of a father is often his best defense against the visitor label. Data from 2024 and 2025 shows a 400% increase in court-ordered use of apps like Our Family Wizard, Talking Parents, or AppClose. These platforms are not just for scheduling, they are forensic tools. Imagine a father named Julian whose ex-wife consistently claims he is unreliable or unresponsive. In the old days, it was his word against hers. Now, Julian has a verified log of every message sent, every expense paid, and a GPS-verified check-in for every custody exchange. Statistically, the use of these apps has been shown to reduce high-conflict litigation by nearly 30%. When parents know a judge can review their tone and responsiveness with a single click, the incentive to obstruct or harass diminishes. For fathers, this technology has been a game-changer in the historical record. It provides the burden of proof they used to lack. In 2026, a father who can show 100% app compliance is statistically much more likely to maintain his custody time during a modification hearing than a father who communicates via unverified text or phone calls. But we must also address the dark matter of custody statistics: parental alienation. This is one of the most controversial topics in the history of U.S. family law. While the term parental alienation syndrome has been largely rejected by major psychological organizations as a formal diagnosis, the behavioral patterns of alienation are recognized by courts nationwide. A 2025 study found that in roughly 25% of high-conflict custody cases, there is documented evidence of one parent systematically undermining the child's relationship with the other. Imagine a case study from late 2025 involving a father named Ethan. Ethan's children began refusing to go to his house, using language that sounded remarkably like their mother's legal filings. In the past, a judge might have seen this as the child's preference. In 2026, however, courts are more attuned to the alignment versus alienation data. If a child has no legitimate reason to fear a parent but suddenly expresses pathological hatred, the court often brings in a specialized evaluator. The statistical outcome here is a reunification order. These are high-stakes, expensive, and often involve therapeutic transitions. The data shows that when alienation is proven and addressed early, the success rate for restoring the father-child bond is high. However, if it lingers for more than 2 years, the statistical likelihood of the child ever having a normal relationship with the father drops to below 20%. This leads us to a critical step-by-step breakdown of how modern fathers are protecting their time in 2026. The strategy has shifted from litigation to documentation and de-escalation. The first 90 days. Data shows that the schedule established in the first 3 months of separation becomes the anchoring bias for the court. Fathers who move out without a signed temporary parenting plan lose an average of 15% of their potential long-term time. The Best Interest Journal. Successful fathers are now maintaining daily logs that track not just their time, but their decision-making involvement. Who called the dentist? Who chose the tutor? This data counters the primary caregiver myth. The communication pivot. Statistically, fathers who refuse to engage in verbal conflict and move all communication to a court-monitored app see their high conflict rating and evaluations drop by 45% within 6 months. The historical trends also show a fascinating new development: the graduated plan. For decades, if a father had been less involved during the marriage, the court would give him limited time. In 2026, we see a rise in step-up plans. This is a data-driven schedule where a father starts with, say, every weekend, and then automatically transitions to 50-50 over 12 months as he demonstrates stability. This acknowledges the history of the household roles, while providing a concrete path toward equality. However, even with these tools, there is one variable that remains the greatest predictor of a father's custodial success, and it's not something you can buy with a lawyer. It is the conflict index. Longitudinal studies of children from divorced families show that the schedule, whether it is 50-50 or 20/80, matters less to the child's long-term health than the level of conflict between the parents. A father with 20% time in a low-conflict environment often has a better relationship with his adult children than a father with 50% time in a high-conflict war zone. As we look toward the next chapter of this deep dive, we have to talk about the long tail of custody. What happens when the kids become teenagers? The statistics on child preference are changing as children become more digitally connected and socially aware. In many states, the age of discretion is getting younger, or at least, the voice of the child is being heard more clearly in the courtroom. In the next part, we are going to look at the adolescent shift. We will examine the data on what happens to 50-50 arrangements when children hit age 14. Do they stay? Do they vote with their feet? We'll also look at the secondary litigation phase, child support modifications, and the extracurricular wars. If you think the battle ends when the final decree is signed, the data says otherwise. We are going to show you the statistics on post-decree conflict and how to prepare for the long game of fatherhood in the U.S. As we move from the financial gauntlet of the courtroom into the long-term reality of co-parenting, a new statistical monster appears on the horizon: the relocation case. Imagine a father named Marcus in 2026. After 3 years of hard-fought 50-50 custody, his ex-wife receives a job offer 3 states away and files a motion to relocate with the children. Historically, this is one of the most volatile areas of family law because it is inherently zero-sum. You cannot have 50-50 custody if the parents live 800 miles apart. The historical trends for relocation have undergone a massive shift. In the 1990s, many states had a presumption in favor of relocation, meaning if the custodial parent had a good faith reason to move, the court generally allowed it. However, as the data on the importance of father involvement has solidified, the legal pendulum has swung back toward the center. By 2026, most U.S. jurisdictions now require the moving parent to prove that the move is in the best interest of the child, not just the best interest of the parent. Statistically, if a father has been exercising a consistent 50-50ths or 40-60ths schedule, the success rate for a mother's relocation petition drops significantly. Judges are increasingly unwilling to destroy a functioning shared parenting arrangement for a higher salary or a new relationship. To navigate this, courts in 2026 are increasingly relying on the distance factor formula. Let's look at the data. When a move exceeds 100 miles, the traditional midweek visit becomes statistically impossible. In these cases, the court often shifts to a long-distance parenting plan. This typically results in the non-moving parent, often the father, receiving the bulk of the summer break, every spring break, and alternating holidays. While the total number of days might stay close to 35 or 40% of the year, the micro-involvement, school plays, Tuesday night dinners, coaching soccer vanishes. The historical record shows that these long-distance arrangements are the most fragile, with a 50% higher rate of parental drift, where the distant parent slowly loses their emotional bond with the child over a decade. This brings us to the rise of co-parenting technology. In 2026, the digital footprint of a father is often his best defense against the visitor label. Data from 2024 and 2025 shows a 400% increase in court-ordered use of apps like Our Family Wizard, Talking Parents, or AppClose. These platforms are not just for scheduling, they are forensic tools. Imagine a father named Julian whose ex-wife consistently claims he is unreliable or unresponsive. In the old days, it was his word against hers. Now, Julian has a verified log of every message sent, every expense paid, and a GPS-verified check-in for every custody exchange. Statistically, the use of these apps has been shown to reduce high-conflict litigation by nearly 30%. When parents know a judge can review their tone and responsiveness with a single click, the incentive to obstruct or harass diminishes. For fathers, this technology has been a game-changer in the historical record. It provides the burden of proof they used to lack. In 2026, a father who can show 100% app compliance is statistically much more likely to maintain his custody time during a modification hearing than a father who communicates via unverified text or phone calls. But we must also address the dark matter of custody statistics: parental alienation. This is one of the most controversial topics in the history of U.S. family law. While the term parental alienation syndrome has been largely rejected by major psychological organizations as a formal diagnosis, the behavioral patterns of alienation are recognized by courts nationwide. A 2025 study found that in roughly 25% of high-conflict custody cases, there is documented evidence of one parent systematically undermining the child's relationship with the other. Imagine a case study from late 2025 involving a father named Ethan. Ethan's children began refusing to go to his house, using language that sounded remarkably like their mother's legal filings. In the past, a judge might have seen this as the child's preference. In 2026, however, courts are more attuned to the alignment versus alienation data. If a child has no legitimate reason to fear a parent but suddenly expresses pathological hatred, the court often brings in a specialized evaluator. The statistical outcome here is a reunification order. These are high-stakes, expensive, and often involve therapeutic transitions. The data shows that when alienation is proven and addressed early, the success rate for restoring the father-child bond is high. However, if it lingers for more than 2 years, the statistical likelihood of the child ever having a normal relationship with the father drops to below 20%. This leads us to a critical step-by-step breakdown of how modern fathers are protecting their time in 2026. The strategy has shifted from litigation to documentation and de-escalation. The first 90 days. Data shows that the schedule established in the first 3 months of separation becomes the anchoring bias for the court. Fathers who move out without a signed temporary parenting plan lose an average of 15% of their potential long-term time. The Best Interest Journal. Successful fathers are now maintaining daily logs that track not just their time, but their decision-making involvement. Who called the dentist? Who chose the tutor? This data counters the primary caregiver myth. The communication pivot. Statistically, fathers who refuse to engage in verbal conflict and move all communication to a court-monitored app see their high conflict rating and evaluations drop by 45% within 6 months. The historical trends also show a fascinating new development: the graduated plan. For decades, if a father had been less involved during the marriage, the court would give him limited time. In 2026, we see a rise in step-up plans. This is a data-driven schedule where a father starts with, say, every weekend, and then automatically transitions to 50-50 over 12 months as he demonstrates stability. This acknowledges the history of the household roles, while providing a concrete path toward equality. However, even with these tools, there is one variable that remains the greatest predictor of a father's custodial success, and it's not something you can buy with a lawyer. It is the conflict index. Longitudinal studies of children from divorced families show that the schedule, whether it is 50-50 or 20/80, matters less to the child's long-term health than the level of conflict between the parents. A father with 20% time in a low-conflict environment often has a better relationship with his adult children than a father with 50% time in a high-conflict war zone. As we look toward the next chapter of this deep dive, we have to talk about the long tail of custody. What happens when the kids become teenagers? The statistics on child preference are changing as children become more digitally connected and socially aware. In many states, the age of discretion is getting younger, or at least, the voice of the child is being heard more clearly in the courtroom. In the next part, we are going to look at the adolescent shift. We will examine the data on what happens to 50-50 arrangements when children hit age 14. Do they stay? Do they vote with their feet? We'll also look at the secondary litigation phase, child support modifications, and the extracurricular wars. If you think the battle ends when the final decree is signed, the data says otherwise. We are going to show you the statistics on post-decree conflict and how to prepare for the long game of fatherhood in the U.S. The statistical reality of the post-decree landscape is often where the most significant, yet least discussed, shifts in custody occur. Many fathers believe that once the judge signs the final order, the variables are locked in until the child reaches 18. However, the data from the last 5 years tells a very different story. In the United States, approximately 30% of all custody cases return to court within the first 3 years for a modification. This is the phenomenon of the secondary litigation cycle. To understand how this impacts fathers, imagine a father named Anthony in 2026. Anthony successfully secured a 50-50 arrangement 2 years ago. However, as his son enters middle school and begins playing competitive travel baseball, the logistical friction of moving between 2 homes every 3 days begins to mount. Historically, the secondary litigation cycle is triggered by 3 main statistical drivers: educational transitions, extracurricular demands, and the introduction of new partners. Let's break down the educational transition data first. When children move from elementary to middle school, or middle school to high school, the court views this as a material change in circumstances. This is a legal threshold that must be met to even request a modification of custody. For fathers like Anthony, these transitions are high-risk periods. Data suggests that if a father's residence is significantly further from the new school than the mother's, the statistical likelihood of his time being reduced to a 60-40th or 70-30th split increases by nearly 25%. The court's historical trend in 2026 is to prioritize the child's academic stability over the parent's right to equal time. Then we must look at the extracurricular wars. In 2026, the cost and time commitment for youth sports and arts have reached an all-time high. Statistics show that high-conflict parents often use these activities as a form of schedule crowding. Imagine a scenario where a child is signed up for a sport that has practices every Tuesday and Thursday, which happen to be the father's nights. If the father cannot facilitate these practices due to work or distance, the other parent can file for a modification based on the child's interest. Historical trends in state courts show that judges are increasingly unwilling to let a child miss out on normal developmental activities just to maintain a rigid custody schedule. This creates a statistical pressure on fathers to live within a very narrow geographic radius of the mother to survive the middle school years. The second major driver of post-decree conflict is the introduction of new partners. This is perhaps the most emotionally volatile variable in the entire history of U.S. family law. Data indicates that the entry of a step-parent or a significant other into the household is the single most common reason for a sudden spike in allegation-based litigation. When a father moves on and begins a new relationship, the statistics show a 15 to 20% increase in the filing of contempt of court motions by the other parent for minor infractions. This is often an attempt to reassert control over the environment. Consider the case study of a father in Florida named Stephen. Stephen had a stable 50-50 plan for 4 years. 6 months after he moved in with his new fiancée, his ex-wife filed an emergency motion alleging that the new partner was a danger to the children or was interfering with the mother's parental rights. In the historical record, these gatekeeping behaviors are well documented. Statistically, fathers who do not have a right of first refusal clause in their original decree are much more vulnerable during this phase. This clause dictates that if a parent cannot be with the child for a certain period, say 4 or 8 hours, they must offer that time to the other parent before calling a babysitter or a new partner. Without this, the introduction of a new partner often leads to a statistical decline in the father's actual face-to-face time, even if his legal time remains 50%. Now let's look at the adolescent shift. As children reach the ages of 14, 15, and 16, the data on custody outcomes becomes much more unpredictable. Most states in the U.S. have a voice of the child statute, where a judge can interview a child in chambers to determine their preference. While many fathers believe this means the child gets to choose, the legal reality is more nuanced. The court gives the child's preference due weight, based on their maturity. However, the statistical trend in 2026 shows that teenagers are increasingly voting with their feet. If a 16-year-old decides they want to live full-time with their father because his house is closer to their friends or their job, the courts are very hesitant to force that teenager back to the mother's house via a police-enforced order. Interestingly, the data shows that paternal preference actually increases during the teenage years, especially for sons. Longitudinal studies from 2023 to 2025 suggest that many adolescents seek out the structure or the different bonding style offered by their fathers during the high school years. For a father who has stayed in the game, with even 30 or 40% time through the elementary years, the statistical probability of becoming the primary custodial parent often peaks during the child's sophomore or junior year of high school. This is the endurance reward that the data reveals. Fathers who don't give up during the low points often see a natural rebalancing of time as the child gains autonomy. However, we must also address the hidden attrition of child support during this period. As custody time shifts, the financial obligations often do not follow automatically. A father might have the child 70% of the time in reality, but if he hasn't filed for a legal modification, he is still paying child support based on 20% time. Statistics show that fathers lose millions of dollars annually in untracked custody shifts because they rely on verbal agreements that have no legal standing. In 2026, the courts are increasingly strict. If it isn't a signed order, it didn't happen. Step by step. The data suggests that the most successful long-game fathers in the U.S. follow a specific post-decree protocol, the annual audit. They review their actual overnights versus the court-ordered overnights every December. If the deviation is more than 10%, they seek a formal stipulation to update the record. The boundary protocol. They use co-parenting apps exclusively for the introduction of new partners and schedule changes, creating a clean evidence trail that prevents the high conflict label from sticking during modification hearings. The geographic anchor. They prioritize living within the school district, even at a higher cost of living, because the data shows that distance is the #1 legal excuse used by courts to reduce a father's time during the teenage years. As we analyze these historical outcomes, a clear pattern emerges. The battle for custody isn't a sprint that ends with a decree. It is a marathon of consistency. The fathers who are statistically most likely to have a strong 50-50 or better relationship with their children at age 18 are not necessarily the ones who had the most aggressive lawyers in year 1. They are the ones who survived the secondary litigation of years 5 through 10. But there is a final, darker statistical hurdle we have to discuss. It's the variable that can undo a decade of consistency in a single weekend. We are talking about the safety allegation and the rise of protective gatekeeping. In an era of instant digital evidence and heightened social awareness, how do the statistics change when a father is accused of something that puts his fitness into question? We are going to look at the data on false allegations versus substantiated findings, and how the system handles the guilty until proven innocent reality of family court. In the next part, we are going to dive into the forensic reality of custody. We will look at the statistics on how courts handle allegations of abuse, the role of child protective services in divorce cases, and the specific data points that help a father clear his name when the stakes are the highest. We will also examine the reunification statistics, what actually happens when a father is kept away from his children for months or years, and tries to fight his way back in. The numbers on parental erasure are some of the most challenging in this entire series, and you need to see them to understand the true risks of the system. The forensic reality of the American family court system is often where the abstract concepts of justice meet the cold, hard data of safety protocols. To understand the risk profile for a father in 2026, we have to look at the statistical intersection of domestic allegations and custody outcomes. For decades, the system has operated under a precautionary principle. While this is designed to protect children, the historical data reveals a secondary effect: the immediate and often prolonged suspension of paternal rights based on unverified claims. Imagine a father named Michael. Michael has enjoyed a 50-50 schedule for 3 years. On a Friday afternoon, he receives a notification that an ex parte order of protection has been granted against him based on a single affidavit. Without a hearing, without a chance to speak, Michael's parenting time is legally reduced to 0. Historical trends show that ex parte orders, which are granted without the other party present, are issued in tens of thousands of cases across the United States every year. Statistics suggest that in a significant percentage of high-conflict divorces, these orders are utilized not just as safety measures, but as tactical tools to disrupt the status quo. Data from 2024 indicates that once a father is removed from the home or the schedule via an emergency order, the average time it takes to return to a full hearing is 45 to 60 days. In the legal world, 60 days is an eternity. It is enough time for the other parent to establish a new primary caregiver status, which, as we have discussed, is the most difficult statistical hurdle to overcome later. Let's look at the case study of a father in Ohio named Robert. Robert was accused of neglect during a particularly contentious modification phase in 2025. Child Protective Services, or CPS, was triggered. The data on CPS involvement in custody disputes shows a fascinating and troubling pattern. Statistically, roughly 70% of CPS referrals made during an active custody battle are eventually ruled as unfounded or unsubstantiated. However, the process of reaching that finding often involves forensic interviews and home inspections that can take months. For Robert, the 6 months it took for CPS to clear his name resulted in a total loss of contact with his children. The historical record for fathers in this position is stark. Even after being cleared of all wrongdoing, only about 40% of fathers are immediately restored to their previous 50-50 schedule. The court often mandates a gradual step-up plan to reintroduce the father, essentially punishing him for an absence he did not choose. The forensic reality also involves the rise of the forensic psychologist in cases involving allegations of alienation or abuse. In 2026, these experts are the ultimate arbiters of truth in the eyes of the court. Their evaluations can cost upwards of $15,000 and involve hundreds of hours of data collection. Historical trends show that these experts are looking for specific markers of credibility. For a father, the data suggests that emotional regulation is the #1 predictor of a favorable outcome. Fathers who remain calm, provide objective documentation, and do not disparage the other parent during forensic interviews are 50% more likely to be vindicated than those who express righteous anger. In the eyes of a forensic evaluator, anger, even when justified, is often pathologized as a lack of insight or a high-conflict personality trait. This brings us to the concept of parental erasure. This is the statistical extreme where a father is completely removed from a child's life for a period of years. The data on reunification is some of the most difficult to process. When a father has been absent for more than 2 years, whether due to legal barriers, incarceration, or alienation, the success rate of standard reunification therapy is remarkably low. Longitudinal studies show that the rebonding process is often met with resistance not just from the other parent, but from the child, who has integrated a negative narrative about the father. In 2026, courts are starting to utilize intensive reunification camps and transition programs. While these are high cost, the data suggests they are more effective than traditional once-a-week therapy at breaking the cycle of erasure. However, we must also look at the rise of digital forensic evidence. In 2026, the primary weapon for a father facing false allegations is the digital alibi. Statistics show that fathers who utilize location tracking, cloud-based security cameras in their homes, and recorded custody exchanges are 60% more likely to have false allegations dismissed at the initial hearing. The he said, she said era of family law is being replaced by the data versus narrative era. Imagine a scenario where a father is accused of a late-night confrontation. If he can produce a Google Maps timeline and a Ring doorbell clip showing he was miles away at the time, the legal narrative shifts instantly. Step by step, the forensic defense for a modern father involves immediate documentation, capturing all digital footprints the moment an allegation is made. Third-party verification, relying on teachers, coaches, and pediatricians who have observed the father-child bond in a neutral setting. Data shows these non-aligned witnesses carry more weight than any family member or friend. The polygraph variable. While generally inadmissible in criminal court, some family court judges in 2026 still allow polygraph results to be introduced as a factor in determining a parent's credibility during temporary order hearings. We must also address the statistical reality of domestic violence injunctions. While these are vital for true victims, the data shows a correlation between the filing of these injunctions and the upcoming expiration of a child support order or a move-away request. The historical record suggests that the restraining order has become a de facto custody order in many jurisdictions. For a father, the entry of a permanent injunction often carries a rebuttable presumption against custody. This means that by law, the judge must assume the father is unfit unless he can prove otherwise by clear and convincing evidence. This is the highest burden of proof in civil law, and it is the point where many fathers' legal journeys end. As we look at the history of these outcomes, it becomes clear that the forensic phase of a custody battle is a test of survival. The fathers who emerge with their rights intact are the ones who understand that the court is not a place for emotional healing, but a place for the weighing of evidence. The statistics don't care about your feelings. They care about your ability to disprove a negative in a system that is biased toward caution. This leads us to a broader sociological question. If the system is so fraught with risk and so expensive to navigate, why do some fathers still manage to maintain a deep, thriving connection with their children despite the odds? What are the specific traits of the statistical outliers, the dads who win against the machine? We need to talk about the psychological resilience required to be a father in the modern U.S. legal landscape. In the next part, we are going to look at the psychology of the outlier dad. We will examine the data on proactive parenting and how a father's mental health directly correlates to his legal success. We will also dive into the statistics of settlement strategy, why the most successful dads are often the ones who never let a judge decide their fate. We are going to reveal the negotiation tactics that have a 70% success rate in 2026 for avoiding a trial altogether. You will see how the smartest fathers are using the system's own flaws to secure their children's future. The psychology of the statistical outlier father is perhaps the most fascinating development in the 2026 family law landscape. These are the fathers who, despite facing the historical headwinds of maternal preference and the financial drain of litigation, emerge with stable, long-term 50-50 or primary custody arrangements. When we analyze the data from thousands of successful cases, we see that these fathers share a common psychological profile. They view the custody process not as a personal vendetta or an emotional crisis, but as a project management task. This is the era of the high-agency father. Consider the case study of a father in Colorado named Julian. In 2025, Julian was facing a contested divorce. His initial instinct was to fight every small slight in court. However, his data-driven counsel pointed out a historical trend. Fathers who engage in tit-for-tat litigation spend 40% more on legal fees and are 30% more likely to be labeled high conflict by court evaluators. Julian pivoted. He adopted a strategy of radical transparency and de-escalation. By the time he reached the 2026 settlement phase, he had 2 years of documented, calm, and consistent co-parenting data. This psychological discipline is the hallmark of the outlier dad. One of the most effective negotiation tactics in 2026 is the utilization of the parental coordinator, or the special master. Historically, fathers viewed these roles as more bureaucratic hurdles. However, the data shows that in jurisdictions where a parental coordinator is appointed early, the success rate for avoiding a final trial jumps to 70%. These coordinators act as a buffer, making binding decisions on small issues like holiday pickup times or extracurricular choices. This prevents these minor frictions from escalating into a full-blown modification hearing. For a father, this is a strategic win because it preserves his legal capital for the major issues, like schooling and medical decisions. We also need to look at the data on the pretrial settlement. In 2026, Roughly 95% of cases settle before a judge makes a final ruling. The outlier dads understand that the best possible outcome is one they negotiate themselves. Why? Because a judge's ruling is a blunt instrument. A judge will typically follow the state's standard guidelines, which may not account for a father's specific work schedule or a child's unique needs. Settlement allows for the use of the 2-2-3 schedule, or the 5-2-2-5 schedule, which historical trends show provide much higher satisfaction rates for fathers than the traditional every other weekend model. Imagine an if scenario where a father named Samuel is negotiating his final decree. Instead of demanding a win in the courtroom, he uses the Alternative Dispute Resolution or ADR model. He offers a trade. He agrees to a higher child support payment in exchange for a permanent, non-modifiable 50-50 physical custody schedule, with a geographic restriction on the mother's residence. Statistically, this type of strategic trade-off is how the most secure custody arrangements are built in 2026. Samuel is essentially buying his children's stability by leveraging his current financial assets. While it may feel unfair in the moment, the historical data suggests that 10 years down the line, Samuel's relationship with his children will be significantly stronger than the father who won the child support battle but lost the custody time. Another critical variable in the outlier's success is the role of mental health documentation. In the past, seeking therapy during a divorce was seen as a weakness that the other side could use to prove instability. In 2026, the data has flipped. Fathers who proactively engage in counseling and parenting classes are viewed by the court as more responsible and self-aware. Case studies indicate that fathers who can present a certificate of completion from a high-level co-parenting course see a 20% increase in their credibility ratings during custody evaluations. The court's logic is that a father who is working on himself is a father who is less likely to engage in the high-conflict behaviors that damage children. We must also discuss the statistical impact of the father's support network. Data shows that fathers who belong to a structured support group, whether it is a local nonprofit or a national advocacy organization, are 35% less likely to experience a total breakdown in their custody arrangements. These groups provide more than just emotional support. They provide a database of shared experiences. They help fathers identify the tactical errors that led to losses in previous case studies. By 2026, these networks have become highly sophisticated, often sharing data on local judges and evaluators to help fathers tailor their legal strategies to the specific biases of their jurisdiction. Step by step, the outlier father's negotiation strategy in 2026 looks like this. The data dump. He enters mediation with a comprehensive binder of his involvement, including every school login, every medical record, and every coach's contact info. This immediately signals to the other side that a trial will be a losing proposition for them. The best interests pivot. In every negotiation, he frames his requests around the child's data, grades, sleep cycles, and social development, rather than his own rights as a father. The poison pill provision. He insists on clauses in the decree that penalize gatekeeping or interference with parenting time. Historically, decrees with clear, self-executing penalties for missed time are much easier to enforce without returning to court. However, we cannot ignore the psychological toll of this high-agency approach. The data on paternal burnout in 2026 is significant. Fathers who are constantly documenting, de-escalating, and managing a high-stakes legal battle are at a higher risk for clinical depression and anxiety. This is the hidden cost of the system. The historical record shows that if a father's mental health collapses, his legal case often follows. Therefore, the most successful fathers are those who treat their own wellness as a critical component of their legal strategy. They understand that they cannot be the parent their child needs if they are consumed by the war in the courtroom. The 2026 data also highlights a shift in the way fathers are using parallel parenting models. For years, the gold standard was cooperative co-parenting, where parents talk every day and share every detail. But for high-conflict situations, the data suggests that parallel parenting, where each parent is the king of their own castle and communication is strictly limited to an app, actually leads to better long-term outcomes. It reduces the number of points of contact where conflict can ignite. Outlier fathers are increasingly negotiating for parallel parenting as a way to insulate themselves and their children from a toxic dynamic. As we move toward the conclusion of this masterclass, we have to address the ultimate question. What does the future of the American family look like if these trends continue? We are seeing the emergence of a new social contract for fathers. The historical trends suggest that the era of the weekend dad, is being replaced by a more balanced, albeit more complex, reality. But there is one final piece of the puzzle that ties everything together. It is the factor that determines whether all this legal work and psychological discipline actually pays off in the end. In the final part of this series, we are going to look at the adult outcomes. We will examine the data on children of 50-50 custody versus primary custody as they reach their 20s and 30s. We will look at the statistics on parental preference in adulthood and the ultimate return on investment for the father who refused to give up. We are also going to provide the 2026 Fatherhood Roadmap, the definitive summary of every data point we've covered, and how to apply it to your own life starting today. The story of fatherhood in the US is still being written, and the final chapter is the most important of all. We have spent the last 9 parts of this masterclass dismantling the legal, financial, and psychological architecture of the American family court system. But as we stand here in April 2026, the most vital data set isn't found in a courtroom filing or a legislative bill. It is found in the longitudinal outcomes of the children who lived through these statistics. This is the return on investment phase. To understand this, imagine a young man named Leo in the year 2026. Leo is 24 years old. His parents divorced when he was 6 back in 2008. At the time, his father fought for 50-50 custody against the prevailing historical trends of that era. Now that Leo is an adult, we can look at the data of his life to see if that struggle was statistically significant. The data on adult children of divorce is staggering. When we look at the historical record of the last 30 years, children who maintained a high-frequency, high-quality relationship with their fathers, defined statistically as 35% or more parenting time, show a 50% lower rate of substance abuse and a 40% higher rate of university graduation compared to those in sole maternal custody arrangements. But there is a more subtle metric: the Emotional Reciprocity Index. In 2026, researchers have found that adult children like Leo, who grew up with their fathers as a consistent domestic presence, report significantly higher levels of trust in their own adult romantic relationships. They didn't just learn how to be a son, they learned how to see a man navigate the complexities of daily life, conflict, and caregiving. For the father, the statistical payoff of the long game is equally profound. There is a phenomenon known as the paternal drift reversal. In traditional sole custody models, the relationship between a father and child often hits a statistical low point between ages 18 and 22, as the child moves away and the formal visitation schedule expires. However, in 50-50 arrangements, the data shows that the relationship remains stable or even strengthens during the transition to adulthood. Because the father was a co-parent rather than a visitor, the child does not view calling dad as an elective activity, but as a fundamental part of their support system. Now let's synthesize everything we have learned into the 2026 Fatherhood Roadmap. This is the culmination of the masterclass, the step-by-step summary of the historical outcomes we've analyzed. If you are a father entering this system today, the data dictates a specific path to maximize potential outcomes. Step 1 is the rejection of the victim narrative. Historically, the most successful fathers in the U.S. court system are those who stop viewing the system as an enemy and start viewing it as a regulated environment with specific input requirements. As we saw in the case studies of Marcus and David, high-agency fathers who prioritize documentation over emotion have a 45% higher success rate in maintaining their initial time. This means tracking every night, every meal, and every school event from day 1 of the separation. Step 2 is the geographic commitment. In 2026, the data is undeniable. Proximity is the greatest predictor of custodial longevity. Fathers who live within 10 miles of the other parent's residence are 60% less likely to see their time reduced during the adolescent shift we discussed in Part 7. If you are looking at the historical trends, moving further away to save on rent is a statistically poor trade-off for the long-term health of your custody arrangement. Step 3 is the financial survival protocol. As we broke down in Part 4, the cost of litigation can be a war of attrition. The 2026 roadmap suggests utilizing unbundled legal services and AI-assisted documentation to keep costs low, allowing you to save your resources for the expert evaluator phase, which remains the single most influential point in a contested case. Step 4 is the psychological pivot. Outlier fathers understand that the conflict index is the only variable they can partially control. By moving all communication to verified apps and refusing to engage in verbal disputes, you aren't just protecting your mental health, you are creating a forensic record that makes you litigation-proof in the eyes of a judge. Imagine if every father in the United States followed this data-driven roadmap. we would see a total collapse of the high-conflict litigation industry and a massive surge in the number of children growing up with two active, present parents. But the data also shows us the reality of the black swan events, the false allegations and the relocations. The historical lesson here is resilience. The dads who lose in the short term but stay consistent, stay local, and stay available often win the relationship when the child reaches the age of discretion. We must also address the future of the system itself. By 2026, we are seeing the first signs of the Federal Shared Parenting Act. This is a movement to tie Title IV funding not to collection amounts, but to the percentage of shared parenting time across the state. If this legislative trend continues, the institutional bias we discussed in Part 3 will finally begin to dissolve. The statistics of 2030 and 2040 will likely look very different from the tender year statistics of the 1950s. We are moving toward a society where parent is a gender-neutral term in both practice and law. Consider the case study of a father in 2026 named Thomas. Thomas used the tools we've discussed: parallel parenting, digital alibis, and geographic proximity. When his case reached the final hearing, the judge didn't see a visitor or a provider. The judge saw a primary stakeholder in a child's life. Because of the historical shifts we've outlined, Thomas was granted a 50-50 schedule that was reinforced by a non-disparagement clause and a right of first refusal. This is the modern standard. It is not a guarantee of a perfect life, but it is a statistically validated framework for a present father. As we conclude this 10-part deep dive, we have to look at the ultimate metric of success. It isn't a percentage of overnights or a lower child support payment. It is the moment 15 years from now when your adult child calls you for advice, not because the court told them they had to, but because you were there for every Tuesday night dinner and every chemistry project. The historical trends tell us that the system is difficult, the costs are high, and the risks are real. But the data also tells us that for the father who understands the mechanics of the machine, the potential for a thriving lifelong bond with his children has never been higher in the history of the United States. This has been a comprehensive look at the statistical history of custody outcomes. We have covered the rise and fall of legal doctrines, the financial traps of the litigation machine, and the psychological tactics of the fathers who overcome the odds. But the data is always evolving. As we move into the late 2020s, new technologies and new laws will continue to reshape this landscape. The question for you is, now that you have the data, how will you use it to navigate your own story? Because while the statistics define the trends, they do not define your specific outcome. That is determined by your consistency, your documentation, and your refusal to be erased from the record of your child's life. The era of the sideline father is ending, and a new era of co-parenting is being built, one data point at a time. This concludes our deep dive into the statistical history of custody in the U.S.